we all know pretty much that discovery is the process of identifying, preserving, collecting, reviewing, analyzing, and producing information. So the goal of discovery is to obtain information that will be useful in uncovering relevant facts for pretrial motions and for the trial itself. Of course, discovery can apply before an action is even filed, or also in matters outside of litigation, such as in the case of corporate due diligence or other things like that. So information sought during discovery can include documents, testimony, and other information that may be deemed necessary. In the past, which we're pretty much all used to, discovery was a process dealing primarily with paper documents. But in recent years, the shift to computers and digital information has created a new specialty called electronic discovery. More commonly referred to as e-discovery, this is simply the continuation of the discovery process to include information that is stored electronically. It includes things like emails, Word documents, presentations, database files, voicemails, audio and video files, social media, and website information. So while e-discovery makes it easier to discover information that would not be possible with paper documents, the procedures and systems used in e-discovery are often complex because of the sheer volume of data that's produced and stored. Unlike hard copy evidence, electronic documents are much more dynamic and usually contain metadata such as time, date stamps, author, recipient information, and file properties. Preserving the original content and metadata for electronically stored information is required in order to eliminate claims of spoliation or tampering with evidence later in the litigation. After the data is identified by the parties on both sides of a matter, potentially relevant documents, including electronic and hard copy paper materials, are placed under a legal hold, meaning they cannot be modified, deleted, erased, or otherwise destroyed. Potentially relevant data is collected and then extracted, indexed, and placed into a database for review. At this point, the data is analyzed to segregate the clearly non-relevant documents and emails. The data is then hosted in a secure environment and made accessible to reviewers who code the documents for their relevance to the matter at hand. And a lot of times this is where paralegals may come in, as they're often used for this space of the document review. So next slide. So e-discovery is really important because almost everything we do in today's electronic world is being recorded and stored. From sending emails to making phone calls, as you know, I'm sure pretty much everyone here has seen on the news lately, everything is being recorded. Or using social media, to swiping a credit card at the grocery store, or using a highway prepaid toll system. We leave behind us a constantly updating trail of electronically stored information, or ESI. The very nature of ESI generally makes it well suited to investigation. As paralegals, we are usually the individuals who are most drastically impacted by the way ESI is changing the entire discovery process. We are usually the ones tasked with the job of figuring out what to do with the equivalent of hundreds, if not thousands, of boxes of discovery documents. Even in a digital form, the evidence still has to be collected, sorted, organized, reviewed, and prepared for production. Attorneys want to review the documents in a simple but efficient way, and clients want to keep the cost to a minimum. So it's important to keep in mind that e-discovery is not a trend. It is definitely an area of practice that is only going to continue to grow. Increasing volumes of ESI, evolving case law relating to e-discovery, constantly changing protocols, and harsher judicial sanctions have placed experienced e-discovery paralegals in high demand. Next slide. So you can really use this to your advantage. Because paralegals have traditionally been responsible for the management of paper discovery, they now have the opportunity to develop new skills by understanding how to best collect, organize, and review the electronic data. By gaining the necessary education and developing e-discovery skills, paralegals position themselves to provide advice and guidance to attorneys, especially those who may be turning to e-discovery for the first time. Learning about e-discovery can make you an invaluable resource, not only to your attorney, but also to your entire firm, as e-discovery is utilized for more and more clients. While many paralegals have limited growth potential, a position in e-discovery can allow a paralegal to utilize their skills and abilities to make an upward move. Paralegals with marketable e-discovery skills have significantly higher earning potential than those without. They also have the opportunity to leave the traditional paralegal role behind and work for an e-discovery service provider or branch out on their own in a number of different ways. Next slide. So let's look at some ways that a paralegal can transition into the e-discovery field. One way to break in is to educate yourself. And while some colleges are starting to get on board with e-discovery education, many don't offer the necessary e-discovery training. However, e-discovery training programs are now available from companies such as the ones represented here today, and certifications in specific software packages and databases are also offered by many litigation support vendors. E-discovery certification is also available upon successful completion of an exam. And obtaining this kind of certification can demonstrate a commitment to your profession, can enhance your professional credibility, and it can also boost your employment options. Depending on your current role, your employer may or may not be willing to assist you with your e-discovery education. While some firms provide financial support and a somewhat flexible schedule which will allow you to gain this education, some simply don't see the value. Some attorneys and firms can be closed-minded when it comes to the continuing education of their paralegals, especially if you are already doing the work that they want you to be doing. They may have a hard time seeing the benefit of investing time and money into furthering your education. You may need to market this idea to your employer yourself and show them the advantages of this kind of investment. An e-discovery education is critical for the future of your professional development. So even if your firm is not a willing participant, it's a worthwhile investment for yourself. Networking is another good way to learn about e-discovery opportunities. Networking with local bar associations, paralegal groups, and most importantly, e-discovery organizations allow you to talk to the people who work in the field to learn more about e-discovery and potential job openings. You can also benefit from networking with e-discovery paralegals and industry leaders by attending e-discovery conferences which draw professionals from around the country. This is another area where your firm may or may not be willing to support you. Many firms recognize the importance of networking for personal and career growth and embrace the benefit of having an established network to turn to for advice. Attorneys practice this every day, but it's really only now recently catching on for paralegals who are serious about advancing in their profession. For new and experienced paralegals alike, a mentor can also be beneficial. A mentor can help teach you the ropes, introduce you to others in the field, and also help nurture your career. If your firm has an e-discovery practice, you may be able to gain a mentor in-house who can help cross-train you within the firm. Even if that means performing extra work on your own time, it's going to be well worth it in the long run. You can also volunteer to assist e-discovery paralegals in your firm, ask questions, and study the rules and case law. If your firm doesn't have an e-discovery practice, connect with a mentor through your local paralegal association or e-discovery organization. E-mentoring is also a growing trend. If you can't find a mentor in your local area, you may have more success online using professional networking groups such as LinkedIn. As the e-discovery field matures, it is attracting skilled paralegals with diverse backgrounds. And while some see the paralegal field being threatened by underemployed attorneys, embracing this growing field can help secure your future. While there isn't one magic key to landing that perfect e-discovery paralegal job, paralegals with the right mix of legal knowledge, technical savvy, and innovative thinking can find a challenging and lucrative career in this growing industry. It isn't easy, but it will be worth it, and you've already taken an important step by attending this seminar today. While e-discovery may seem like a daunting new field to some, there are an endless amount of resources available just waiting for you to jump in and get started. So now I'm going to turn it over to Tondalia, who's going to give you an idea of the day-to-day responsibilities and obstacles an e-discovery paralegal may encounter.